Anderson County Bar. I'm here on behalf of the appellant, Mr. James David Duncan. I would respectfully request to reserve 5 minutes of rebuttal.
Certainly.
The sole issue raised in this appeal on behalf of Mr. Duncan is whether the trial court erred in dismissing Mr. Duncan's petition for post-conviction relief for being untimely and barred under the statute of limitations without adequately considering due process tolling. Specifically, the issue that we raised was that the statute of limitations should have been tolled pursuant to Whitehead v. State. Procedurally, what happened in this case, it all began in 2019. On January 14th of 2019, Mr. Duncan entered a guilty plea in Anderson County Criminal Court to a B felony drug charge, to my recollection. He was revoked to TDOC custody on January 7th of 2020. The statute of limitations for him to have filed a petition for post-conviction relief on the original plea would have elapsed on February 13th of 2020. Mr. Duncan, he did appeal his revocation, and that was affirmed by this honorable court on August 4th of 2021. A Rule 11 application was filed on that, which was denied on November 17th of 2021. Mr. Duncan filed a pro se relief that was signed, notarized, and contained factual allegations on December 27th of 2021. And then an amended PCR was filed with the assistance of counsel on Mr. Duncan's behalf on July 28th of 2023. The trial court, in ruling to dismiss Mr. Duncan's amended petition for post-conviction relief, indicated that the decision was decided based on the undisputed timeline of events in this case. And it is correct that the timeline is not in dispute in this matter. What is in dispute is whether Mr. Duncan, during this timeline of events, was diligently exercising his rights, and whether there were extraordinary circumstances that stood in his way and prevented him from filing. A hearing on the sole issue of the dismissal was held on March 1st of 2024. After Mr. Duncan had filed his amended pro se petition for post-conviction relief, the state filed a motion to dismiss, and so on that March 1st, 2024 court date, the sole issue that was being addressed was whether or not due process tolling would prevent Mr. Duncan's petition from being dismissed. During that hearing, Mr. Duncan testified on his behalf, and that was the sole proof that was provided by the petitioner. The state did not provide any proof. And regarding beyond the timeline, there was a history of change of attorneys in this case. I was the fifth attorney when I was appointed on April 19th of 2022. Originally, Mr. Duncan, he had Ms. Stephanie Jernigan, who we referred to in the brief as first trial counsel of the Anderson County Public Defender's Office. She represented Mr. Duncan through the plea stage. There was Ms. Nancy Meyer, who we refer to as second trial counsel, who represented Mr. Duncan during the revocation stage. Then the Honorable Matt Tuck, who is now, of course, a judge, he was appointed as substitute counsel during the revocation stage of this case. Then Mr. Andrew Pate was appointed as first post-conviction counsel, and then when he took a job at the Anderson County Public Defender's Office, he had to conflict off the case, and then I was appointed as second post-conviction counsel. And so what this case really comes down to is whether the efforts that Mr. Duncan made during the pendency of this case would necessitate due process tolling under Whitehead. Mr. Duncan, he testified during his post-conviction hearing as to the efforts that he made to fulfill the prongs of Whitehead. Mr. Duncan testified that after his initial guilty plea, he attempted to contact first trial counsel via telephone, but she never called him back. Mr. Duncan testified next that he attempted to contact second counsel trial counsel via telephone, but he did not receive a response. And then when he appeared in court when he formally appeared on his violation of probation, he directly asked second trial counsel about filing a petition for post-conviction relief. And he had indicated that he wanted to file a petition for post-conviction relief against first trial counsel, since first trial counsel had overseen the plea. The post-conviction petition was never adjudicated on its merits because the motion to dismiss was heard first in time. But the basis for the allegation in the amended post-conviction relief was that Mr. Duncan's underlying plea from January 2019 was not knowingly, intelligently, and voluntarily made. And as a preliminary matter at that point, an issue I'd like to address, and I'm sure it's on the mind of your honors, and it was certainly on the mind of the post-conviction court, was why did Mr. Duncan not diligently exercise his rights prior to being revoked on his probation? And we know from...
Well, can I just ask a question?
Yes, Your Honor.
Before you get there, the post-conviction court here seemed particularly not aggrieved, but concerned that there was the sole testimony was from the petitioner here, which the court, I think, found not credible, correct?
Your Honor, specifically what the post-conviction court noted was that Mr. Duncan's testimony, I believe the language the court used was incredibly self-serving, and it was on that basis that the court discredited the testimony of Mr. Duncan.
So why no testimony, no affidavit from, trial counsel here? There was, if there was a legitimate concern prior to the revocation of the probation, that's something that, we all would expect. Is that not accurate? Is that not fair?
Yes, sir. That's certainly a fair inquiry, and it would certainly bolster the appellant's case if there was corroborating testimony from the 4 preceding attorneys that had been involved in the case. But Mr. Duncan would submit that he did provide his testimony under oath. The court discredited it. The court, and of course, found that it was incredibly self-serving. I do not recall from the record, and if I'm incorrect, I would defer to record. I don't believe that the court specifically said that Mr. Duncan was lying or that he was committing perjury. It was just that it was incredibly self-serving. The court did discredit it, and the practical effect is perhaps the same as far as this court's analysis. But I would also submit on Mr. Duncan's behalf that he did have the letter that was contained within the record of the letter that he had received from Mr. Tuck, now Judge Tuck, and I'm just going to refer to him as I don't want to be disrespectful and say Mr. Tuck when he's Judge Tuck. I'll say Judge Tuck out of abundance of caution. Judge Tuck had informed Mr. Duncan in this letter that he had exhausted all of his state rights, and then at that point, the only avenue that he had left was collateral attack. And there was some discrepancy in Mr. Duncan's testimony. At first, he had testified, I believe, that was the moment that he had realized that his prior counsel had not filed a petition for post-conviction relief. But of course, the date that he filed his pro se petition back in December predated the letter that he had received from Mr. Tuck. But Mr. Duncan, he also admitted that he did have some memory issues, and to his credit, it is 5 years, almost 5 years of time that was being accounted for. But to answer Your Honor's question succinctly, we would submit that while that other testimony would have been helpful, it wasn't absolutely necessary for Mr. Duncan to assert his claim based on his testimony as well as the corroboration that he had through Judge Tuck's letter. And so for the sake of time, it's briefed. I won't go through every single issue, but what we see is that time and time again, Mr. Duncan was attempting to exercise his right. And I think it's important to look to the language of Whitehead that says, in terms of diligence, courts have recognized that due diligence does not require a petitioner to undertake repeated exercises in futility or to exhaust every imaginable option, but rather to make reasonable efforts. So that, of course, is a central inquiry to this, is whether Mr. Duncan's efforts were reasonable, But then we look further into the Whitehead language and it says, moreover, the due diligence inquiry is an individualized one that must take into account the conditions of confinement and the reality of the prison system. Mr. Duncan was out of custody for a brief period of time before he was revoked to serve his sentence in TDOC. So for the vast majority of this timeline, from January of 2019 through March 1st of 2024, for the vast majority of that time, Mr. Duncan was in custody as a TDOC inmate. And Mr. Duncan testified that he, as an individual, had an 11th grade education. He had no formalized legal knowledge. And I do not recall specifically if Mr. Duncan addressed this issue in his testimony, but it seems to me in observing the record that perhaps he had there was some confusion on his end, because he thinks that a petition for post-conviction relief has been filed due to the representations by his prior counsel. But he's also pursuing appellate relief on the violation of probation. And then eventually he does file a pro se petition for post-conviction relief. But I think if we look at the whole entire picture, this is an individual who's trying to assert his rights. He may not know the best way to do it due to his lack of formal legal education, but every step of the way, he's trying to exercise his rights. He's relying on the assertions that have been made to him by his prior attorneys, and he doesn't realize until far after the statute of limitations that it's already passed and nothing's been filed and nothing has been preserved. And Mr. Duncan specifically testified to, when we look at second factor of Whitehead, whether there were extraordinary circumstances that stood in his way and prevented him from filing, there is, of course, abandonment by counsel, which is one factor that the court can look at. And Mr. Duncan submitted during his testimony that the conduct of first trial counsel and second trial counsel did constitute abandonment because with first trial counsel, Mr. Duncan testified that first trial counsel just didn't communicate with him. With second trial counsel, he testified that second trial counsel had represented to him that she was going to be filing a petition for post-conviction relief. And so beyond abandonment, as with the conduct of second trial counsel per Mr. Duncan's testimony, there's also an issue of whether Mr. Duncan was misled in believing that his petition for post-conviction relief had been filed. With first revocation counsel, Judge Tuck, there wasn't any allegation of abandonment or miscommunication. And of course, Judge Tuck was helping him with the appeals process on his revocation. But during that time, he was still operating under the representation made by second trial counsel that a post-conviction petition had been filed. And then with first post-conviction counsel, Mr. Duncan testified to a deficiency in communication between the two of them. And that first appellate counsel was appointed for a relatively short period of time before I was appointed as second post-conviction counsel. But during that 3-month period, that first post-conviction counsel represented Mr. Duncan. He did testify at the hearing that there was a deficiency in communication with them. And we would submit that that would qualify as abandonment if an attorney is not communicating with their client. And going back to the Whitehead language, where we have to take into account the conditions of confinement and the reality of the prison system, it is more difficult for somebody who's in TDOC custody to establish contact with their lawyer. That individual doesn't have the luxury of being able to go to their office. They don't have the ability to really control their lives or their avenues of communication the way that somebody who's not incarcerated would not. And so if the court doesn't have any additional questions at this time, I will yield my podium to the general.
Quick question.
Yes, Your Honor.
He got a 10-year sentence, let's see, 2019, you said January of 2019. Yes,
Your Honor.
Probation.
Yes, Your Honor.
Got probation. How much time passed before the probation was revoked? The first time I thought it was about a year, but then when you said he was in prison most of the time, I may have gotten confused.
No, Your Honor, I've almost certainly created that confusion. He was out of custody for about a year before he was revoked. It was not a full calendar, pardon me. He pled on January 14th of 2019. He was revoked to serve to TDOC custody on January 27th of 2020. So it was a little over a year before he was revoked.
Okay.
Thank you, Your Honor.
One more quick one.
Yes, Your Honor.
I asked this on an earlier case, and I should know the answer, but the judge in Anderson County, Judge Spitzer, I think, he's the one that made the call here that the statutes run, you don't get any relief. And so for us to give you relief, we have to say he abused his discretion. Is that the standard of review?
No, Your Honor. I cited this in my brief, and correct me if I'm mistaken. An appellate court reviewing a post-conviction court's conclusion of law, it's a de novo standard of review. However, if the court is evaluating the findings of fact that were made by the post-conviction court, then this court is bound by those findings unless the evidence preponderates against them.
Okay.
So it's if I'm stating it correctly, and it's the first time I've argued one of these, but I would submit that it's a preponderance of the evidence standard.
So we could be bound by the judge's assertion that his testimony is incredibly self-serving. Yes,
Your Honor.
We're bound by that, more or less, is what I'm hearing you say.
Right. And I know I'm over my time, but one thing I would just like to
That's
say
my
to
fault.
that
Yeah,
is that just because something is self-serving doesn't mean that it's untrue.
right.
There's the circumstances where everything could line up for a person to raise a legal cause of action. And sure, that may seem convenient. It may seem perhaps too convenient, but that doesn't mean that it's untrue.
All right, thank you.
Thank you, Your Honor.
General.
Thank you, Your Honor. May it please the court and counsel, my name is Will Lundy, and I represent the state of Tennessee in this appeal. And before I get started, I would just like to thank my friend here and this court for being patient with me. This case was originally docketed for oral argument, I believe, in November, and I lost my voice and could not appear. And then it was docketed again in February, and I got COVID and could not appear. And everyone has been very gracious with me, and I certainly appreciate that. So I want to get that out of the way first. With regard to the merits of this appeal, however, the problem with this case, Your Honor, is that the post-conviction court completely discredited everything that the petitioner said. This court defers to the post-conviction court's credibility determinations unless, as counsel said, the evidence preponderates against it. There is no other evidence. There's no other evidence aside from the petitioner's testimony to preponderate against the trial court's or the post-conviction court's conclusion that the petitioner's testimony was not credible. And that disposes of this case. There really isn't, every assertion of fact that the petitioner has made in terms of his testimony, in terms of his brief, those are not facts that the post-conviction court found to be credible or true. We just don't have any credible information about whether the defendant was diligently exercising his rights to post-conviction or that extraordinary circumstances prevented him from filing his petition. In fact, if I remember correctly, what the court found was that the petitioner didn't start even thinking about this petition for post-conviction relief until after he was sent to prison after the probation revocation. So that would have been after January of 2020. And again, the statute of limitations would have elapsed the next month, and no petition was filed, and there's just simply no evidence in this record to indicate that the petitioner was doing anything during that time. Does the court have any questions for me? If not, I would cede the remainder of my time. Thank you, and ask this court to affirm.
All right, thank you, General.
Thank you, Your Honors. The only points that I would raise on rebuttal, being mindful of not trying to reiterate my entire principal argument, is that the state contends that there was no ever evidence beyond Mr. Duncan's testimony. I would just remind the court that beyond Mr. Duncan's testimony, and I would ask the court to consider, and the court has that power because the court can review the record and determine whether by preponderance of the evidence it does seem that his testimony was self-serving and should be discredited. So I would ask the court, of course, to review the record and make its own determination as to Mr. Duncan's credibility. Because again, it was a situation where the court didn't outright call him a liar, it didn't accuse him of perjury, he wasn't formally impeached or anything like that during his testimony. It seems that the court, and I, of course, would never venture to put myself in a judge's mind, and I have great respect for Judge Spitzer, but I would submit respectfully that this seems to me to be a situation where the trial court views it as self-serving because it lines up too well with the elements of Whitehead.
The trial court's order specifically spoke to the fact, too, that there were no other witnesses. Like, it was almost as if the trial court was saying, I wish you would have called at least one of these prior lawyers. I don't remember the exact language, but as I read through it, it was something to that effect that, you know, the trial court wanted to hear more, you know, from the lawyers in this case that had been involved, or that the defendant had alleged had told him these things. So it was more, I think, of a combination of the self-serving, and I really wish you to put on more proof. So I just want to say, are you appointed on this case?
Yes, Your Honor.
I really appreciate the fact that you know, agreed to take the appointment. And you've done an excellent job in this case. We, as a court, have seen really a dearth of lawyers who are willing to step up to the plate and take appointments. So, especially in sometimes difficult cases like this. And even on top of that, willing to do an excellent job, not only in brief, but in argument. So I applaud you, I appreciate you, and I hope you continue to take appointments for the court.
Thank you, Your Honor. And I greatly appreciate the court's words, and it's my honor to serve the indigent clients that we have here in Tennessee. One point, just as far as the additional witnesses, I would say it would certainly be helpful if that testimony had been presented at the hearing, but I would just iterate that it would have been helpful, but it wasn't absolutely necessary, and that shouldn't be dispositive of the case, and that the court should look to not only Mr. Duncan's testimony, but to the letter by Judge Tuck that's part of the record. And the last point I would make is regarding Mr. Duncan not exercising his post-conviction rights until the revocation process began. There's one broad point I'll make and one specific point. The broad point is that if we look to the amended petition for post-conviction relief that was part of the record, it said that it was alleged that Mr. Duncan, he entered his plea involuntarily. It wasn't knowingly, intelligently, involuntarily made. Specifically, Mr. Duncan was alleging in his amended petition that he felt coerced by first trial counsel into taking the plea because he was informed that if he didn't take the plea, he was going to go to prison. And I understand that if somebody waits that long to do something, it is going to create an air of suspicion to any court, the post-conviction court or an appellate court reviewing it. But I would submit to your honors to consider that if somebody felt coerced into getting a guilty plea, and they felt coerced by their trial counsel out of fear of prison, it's much easier to stomach an agreement you felt coerced into entering into when you're not actually in prison. And when you are facing TDOC incarceration, then you really realize you shouldn't have made that decision. So I would ask the court to consider that as far as the broad point. And again, and with the specific point, there was also testimony from Mr. Duncan that he had tried to reach out to first trial counsel before the revocation. But it wasn't until the revocation that he formally was able to request the PCR, because that was the first time that he had contact with the attorney. That yields my time. I would ask this court to reverse the ruling of the post-conviction court and remand this matter to a hearing consistent with its opinion. Thank you.
All right, thank you, Mr. Zinser. I think that's all our cases for the morning. We have start up again at 1:30. All right, we'll be in recess till 1:30. All right.